Can your smart little chatbot like ChatGPT get sued for copyright infringement because it got to be a smarty pants from copyrighted material? Well, folks, that's already happening. Welcome to the world where artificial intelligence meets copyright law, a world filled with testy lawyers and endless legal dramas. Let's consider AI models like chatbots and large language models. It seems that in their relentless pursuit of knowledge, our dear AI chatbots might have bitten off more than they can chew. You see, in their quest to know all and be all, they've been siphoning off data from every nook and cranny of the internet. And some folks aren't too happy about it. Take the Bloomberg article that recently made headlines. It reported that copyright holders are demanding a share of the profits from AI chatbots that use vast quantities of copyrighted data for their training. But how exactly do these AI models get their training data? Well, they learn from a variety of sources, such as books, websites, databases, and much more. They analyze this data, identify patterns, and use these patterns to make predictions, decisions, or generated output. In essence, they're like a ravenous child gobbling down a birthday cake. Only thing is, this birthday cake is baked with copyrighted ingredients. Now, this is where things get tricky. If an AI model uses copyrighted data for its training, does it infringe on those copyrights? After all, the model isn't exactly reproducing the data. It's learning from it, much like a student learns from a textbook. But unlike a student, AI doesn't just learn the facts. It also learns the sentence patterns, the paragraph structures, and the comparisons to similar data. It's an interesting conundrum. On the one hand, generative AI needs a solid factual foundation to learn from, and that often draws on copyrighted works. On the other hand, we have the legitimate concerns of copyright holders, who deserve recognition and compensation for their work. So the question remains, does the use of such data by AI constitute a copyright violation? When new technology emerges, lawsuits will eventually follow, just like night follows day. There are at least 20 cases already in the legal arena. Here are a few notable ones. Let's delve into the first case involving an AI chatbot, ChatGPT. The claim? This chatbot was accused of sucking up a treasure trove of data, infringing on copyrights left and right. The opposing parties are the New York Times versus OpenAI, the creator of ChatGPT, and its investor Microsoft. The newspaper company accuses OpenAI and Microsoft of becoming petty intellectual property thieves. It claims ChatGPT can crank out near exact replicas of New York Times articles because it was illegally trained on those same articles. I mean, who needs to pay the New York Times for news if you can get it for a lot less from ChatGPT? OpenAI and Microsoft claim, on the other hand, that ChatGPT is not designed to cough up replicas of news articles, and that the New York Times had cleverly engineered a series of unusual prompts to provoke ChatGPT to produce those cherry-picked results. Kind of like hacking the system through an unintended bug in that system. The verdict? Well, it's still up in the air, but it certainly generated a lot of publicity for the newspaper company. It's seeking $450 billion in damages, and it hopes this penalty should teach the naughty chatbot from stealing from the cookie jar. Next, we have the case of Getty Images versus Stability AI. Getty Images sells the use of its immense library of stock images through licensing fees. It claims, however, that Stability AI, which produces AI-generated artwork, was using its library of copyrighted images to train the AI, but without getting permission first from Getty. Essentially, Getty was claiming Stability AI of theft, obtaining an education for its image AI for free at the expense of Getty. Stability AI can generate a never-before-seen image of a cat wearing a silly little hat, eating a vanilla ice cream cone, for example. Getty claims that Stability uses what it learned from pictures of cats, hats, and ice cream cones from Getty's library to eventually generate that synthetic image. Stability AI argues that Getty is missing the whole point of generative artwork, which is, quote-unquote, to generate new and original synthetic images, which do not correspond to any particular previous example processed by the model during training. In other words, there are not many images, if any at all, in Getty's library of cats wearing silly hats, eating ice cream cones. This case is also pending. We will see whether this frozen dairy-loving feline is a copycat, infringing on copyrights. Last but not least, There's the case of book authors suing Facebook owner Meta Platforms. Sarah Silverman and Richard Kadri sued Meta Platforms, claiming the company illegally used their books to train Meta's AI model called Llama. Interestingly, the judge threw out some of the authors' claims. For example, the authors claim that Llama's outputs are an actual derivative of their books makes no sense. Unless the authors can prove that every output generated from Llama is substantially similar to their books, they don't otherwise have a leg to stand on. With most of the authors' claims dismissed, the only one that remains is that Meta used their books to train the AI. We have yet to see whether the training is itself a copyright infringement. These lawsuits show that the intersection of AI and copyright law is a legal minefield. We'll see what eventually explodes. And what turns out to be a dud? Now, what about fair use? Could this legal concept be a shield against copyright infringement accusations? So let's dive right in and try to untangle this fascinating question. Fair use promotes freedom of expression by permitting the unlicensed use of copyright-protected works in certain circumstances. It's like a safety net, designed to prevent the stifling of creativity and innovation. It allows for limited use of copyrighted material without needing permission from the rights holders. Now you might be thinking, well, that sounds like a perfect solution for our AI platforms, right? And you wouldn't be entirely wrong. The fair use doctrine could potentially be applied to AI platforms that use large volumes of copyrighted data for their learning and training processes. Here's the catch, though. Fair use isn't a free-for-all. It's not a free pass to copyrighted material. It's determined on a case-by-case basis, considering factors such as the purpose of the use, the nature of the copyrighted work, the amount of the portion used, and the market effect on the copyrighted work. So, can AI platforms hide behind the shield of fair use? Maybe, but it's a complex issue, and there's still a lot of legal ground to cover. We're in a new age of technology, and the law is playing catch-up as usual. While fair use might offer some protection, it is not a one-size-fits-all solution. The answer may not be as clear-cut as we'd like. Given the complexities of this issue, what are some potential solutions? How can we allow AI to continue advancing while also respecting copyright laws? It's similar to allowing a race car to speed, but with certain guardrails put in place. First, we may consider new legislation. Just as the advent of the internet necessitated the creation of new laws, so too might the rise of AI. These new laws could straddle the line between innovation and protection, ensuring that AI can learn from the vast ocean of information, but not to the detriment of content creators. However, drafting such legislation would be as tough as trying to catch a greased pig at a county fair. It'd need to be specific enough to be effective, yet flexible enough not to stifle the spirit of innovation. Second, licensing agreements could be an option. AI platforms could make arrangements with content creators or copyright holders, allowing the use of their material in return for compensation. It sounds like a fair trade, right? But negotiating these agreements would be as complex as grandma's quilt pattern, especially with the sheer volume of data AI needs to learn. The good news is this approach is showing some success. The Associated Press, the Financial Times, and Germany's Axel Springer have already entered such licensing deals with OpenAI. Often, these deals succeed if the parties can agree to the right price. Perhaps this is what the New York Times is really jockeying for, using their lawsuit as a pressure tactic to get the right settlement with OpenAI. Lastly, we could explore technological measures. Perhaps AI could be designed to avoid copyrighted material or extract only non-copyrighted content. It's a promising thought, but the practicality of it is as elusive as finding a polar bear in the Amazon jungle. While there's no easy answer, these potential solutions offer a starting point for much-needed work regarding AI and copyright law. Perhaps the lawsuits we referred to earlier can help set a foundation that can eventually benefit us all. And vanilla ice cream-loving felines, sporting crazy little hats, won't be banned as copyright thieves. If you would like more updates about ice cream-loving felines, please subscribe and support our YouTube channel. It helps us build a community. And feel free to leave comments or suggestions for other AI topics you are interested in. Until the next time.